Hello. Okay, so for this one, we're going to combine skill 411, which is reading case law for stories to analogize to, and skill 412, which is answering the question of how many cases do we need. Okay, so turning to this case chart that I made, these are all the cases that I read and I liked somehow. Of course, I was doing analogy while I was reading these. And I'm landing on these three. Campbell, because it's Supreme Court, and because it's somewhat similar where they're using the same music, but they're really changing the music. Now, Leibowitz isn't about a song. It's about a photo. But it's interesting that the court read into it a parody where the Leslie Nielsen was actually using the Demi Moore Vanity Fair photo to promote a movie, 33 1/3 or something like that. And so they weren't really trying to make fun of the photo. They were trying to promote the movie. But the court found that, yeah, he could have been making fun of the movie. So that actually leans towards finding a fair use. Now, it's only a persuasive case, but we don't have a lot from the Sixth Circuit. Sixth Circuit isn't a big intellectual property circuit. So that's okay. We can use the Second Circuit. And then the final one is Henley. That I like in terms of an analogy because it's dead on with ours, like factually. It's where somebody used the music without changing it. Okay, in Campbell, they changed it. In Leibowitz, they changed the photograph. Here, they didn't change the music at all, just like Kylie Williams didn't change the music at all. But then they changed the words and made the words about a politician, not about Don Henley, not about the Eagles, not about the music, not about the lyrics, but about somebody totally different. Okay, so those are the three that I really like. So this gets us to skill 4.12, which is answering the question of how many cases do I need. And I always see case law on a spectrum where on one side you want to fill in cases where the element is satisfied to on the other side where it's not satisfied. So here we have Campbell very clearly satisfied. They changed up the music. They changed up the lyrics. They were definitely making fun of it. On the other side, you have Henley where it's like they just stole the music outright and the court said, yeah, you can't do that. That's not a parody. That's a satire. We protect parodies. We don't protect satire. And then in the middle, you have Leibowitz, which is a little of both Campbell and Henley. And so we can do a nice job of using these in our memo. So in the end, I'm going to end up using these three main cases. Campbell also provides the black letter rules for a lot of this stuff. So we'll use that for that as well. Okay, so that answers the question of how many cases. We're going to use three because it provides a nice spectrum and we can do some nice analogies to all of them and some contrasting and some comparing as well. Okay, so I'll see you back in the workbook.